for spending federal money, Part 1.
Studying appropriations law can be a bit intimidating. This involves reading lots of laws, regulations, and opinions that cover many years of our nation's history. And while this is a worthwhile study, which I heartily endorse, nevertheless, I believe that the basic principles of federal appropriations law can be summarized as a set of 8 rules that I call the rules for spending federal money. I'm not suggesting that learning these 8 rules is a substitute for a more extensive study of appropriations law, but I do believe it can help provide both a structure and an entree into this fascinating topic. So, the goal of this video is to avoid the intimidation and help you get your arms around this broad topic while providing the key principles involved in spending federal money. So let's get started. Rule number 1, Congress makes the rules. We have to start somewhere, so we go back to the beginning. All the rules begin, of course, with the Constitution. Our high school government classes taught us that our Constitution created 3 branches of government with specific roles. Article 1 created the legislative branch, which makes the laws. Article 2 created the executive branch, which enforces the laws. And Article 3 created the judicial branch, which interprets the laws. For this session, we will primarily focus on the legislative and executive branches. So, by giving Congress the authority to make the laws, the Constitution confers on Congress authority over spending federal money. This is referred to as the power of the purse. The founders, in their infinite wisdom, created a system of checks and balances in writing the Constitution. The intention was to maintain a balance between the branches. The power of the purse provides Congress with enormous power over federal spending. But since it's the executive branch that actually spends most of the money that Congress makes available, this system of checks and balances has therefore created a bit of friction over the years between the legislative and the executive branches on this exercise of the power of the purse. Most of the rules for spending have evolved as a direct result of that friction. But let's get back to rule number 1. It arises from Article 1, Section 9 of the Constitution, which tells us, "No money shall be drawn from the Treasury, but in consequence of appropriations made by law." In other words, if Congress doesn't appropriate it, we can't spend it. But before we go any further, let's discuss what we mean by spend. Spending is a subject we all know something about. It's what we do with money. Indeed, the Merriam-Webster dictionary defines spend as to use money to pay for something. But if you think about it, much of our normal spending can actually be broken down into 2 steps: a promise to pay and the actual payment itself. For example, if you get a loan for a new car, you first sign a contract that stipulates you will make a certain number of payments of a particular amount for the car. By signing the contract, you are promising to make the payments. We call this promise to pay an obligation. Once the payments are finished, the obligation goes away. Using your credit card to buy some new clothes involves a similar process. When you sign the credit receipt, you are promising to pay the bill within a certain number of days after you receive it. This is also an obligation. Once you pay that bill, the obligation ends. The process of spending federal funds can also be broken down into two distinct steps: a promise to pay, which we call an obligation, and the payment itself, which may also be referred to as an outlay, expenditure, or disbursement. OMB defines an obligation as a binding agreement that will result in outlays immediately or in the future. For example, if an employee of the government signs a contract on behalf of the federal government, there is a promise to make payments in accordance with that contract. This binding agreement is an obligation. Once the payments are made, the obligation ends. The payment to liquidate the obligation is what we call the outlay. As noted, outlays may occur in the same year as the obligation or in a later year. The outlay liquidates the obligation, that is, makes it go away, sometimes all at once with a single payment, or over a period of time with a series of payments. So, while spending covers both obligating and paying, the critical step is the promise to pay, the obligation. The concept of an obligation is central to appropriations law, and therefore all of the subsequent rules relate in some way to this concept. In summary, rule number 1, Congress makes the rules, otherwise described as the power of the purse, is based on the Constitution and is the source of all the remaining rules. As we will see with the development of the other rules, there has not always been agreement or a perfect balance between the legislative and executive branches on this power of the purse. Let's move on to rule number 2. Rule number 2, spend only for purposes authorized by Congress. This should be obvious. If Congress makes the rules, then it logically follows that the executive branch must spend the money Congress appropriates for those purposes Congress has authorized. But, as mentioned earlier, there's not always been unanimity between the legislative and executive branch concerning the power of the purse. In the early days of the Republic, the executive branch did not always spend appropriated dollars for the purposes stated by Congress. So how did Congress react? By passing a law that made this rule very clear. In 1809, Congress amended the acts that established the Treasury, War, and Navy departments by requiring that the sums appropriated by law for each branch of expenditure in the several departments shall be solely applied to the objects for which they are respectively appropriated, and no other. This language, which has been codified in Section 1301 of Title 31 of the U.S. Code, is referred to as the Purpose Statute. Appropriations shall be applied only to the objects for which the appropriations were made. Okay, so now we know the rule. But how does Congress let us know what they intended the funds to be spent for? Well, there are several ways. First of all, Congress passes authorizing legislation. Congress passes laws establishing programs and authorizing legislation. In these laws, Congress tells the executive branch the purposes for which the appropriations are to be spent. For example, the authorizing legislation for the Ryan White HIV/AIDS program in the Public Health Service Act establishes a program of grants for the purpose of assisting in the provision of services related to HIV/AIDS. Authorizing legislation expresses congressional purpose in fairly broad terms. The second way Congress establishes purpose is through appropriation language. When Congress appropriates funding, it stipulates in appropriations language what purposes the funds are to be used for. In this example, Congress provides appropriations for carrying out the Ryan White HIV/AIDS program authorized in Title 26 of the PHS Act. Note that the appropriating language refers to the authorizing legislation, which has established the broad purpose for the appropriation. Notice also that Congress may go into a bit more detail by providing an earmark. GAO defines earmark as a legislative provision that directs funds to be spent on specific projects. In this case, not less than $900,313,000 is to be used for state AIDS drug assistance programs. This language provides a way for Congress to identify certain funding they want spent for a particular purpose. The third way Congress notifies the executive branch of the purposes they expect funds to be spent for is through legislative history. Legislative history encompasses the entire legislative process. If you really want to understand what Congress means regarding purpose, you could consult all of the documents that are created during that process. That would include committee hearings, comments in the congressional record, bills, amendments, committee reports, House, Senate, and conference. Normally, the conference committee report for the final appropriation provides sufficient congressional details concerning how they wish to see funds spent within an appropriation. But, unless specifically referenced in a law, this information is not legally binding. Here's a sample of a conference table, including a bit more detail about the Ryan White program we have been discussing. Here we can see Congress listing in some detail the purposes for which the Ryan White appropriation was made, in the form of a list of programs, projects, and activities that make up Ryan White. With all this information, one can get a pretty good idea what the congressional intent is regarding the purposes for the funds being appropriated, all the way down to the individual program, project, and activity level. Keep in mind, if the purpose is specifically stated in law, we are required by law to follow it. Tables found in committee reports are not law. If we deviate from the amounts, however, we are frequently required to let Congress know through a process called reprogramming. A reprogramming is just what it sounds like, a change in amounts between programs. Congress is allowing a slight repurposing between programs, but still following the general purposes stated in the appropriating and by reference authorizing language. Since Congress gave us the list, they expect us to follow it or notify them why we want to change it. For example, suppose we would like to spend a bit more than $13.1 million on AIDS dental services and a bit less on education and training centers. This slight change in purpose would be handled by sending a reprogramming letter to the Congress in accordance with their instructions. If we don't follow these rules, we may find that Congress will use more restrictive language in a law in the future. In certain circumstances, we might even find ourselves violating the Anti-Deficiency Act. It doesn't pay to mess around with Congress. There is another permissible way to repurpose appropriations, and it also requires statutory authority: transfer. While a reprogramming involves shifting funds within an account, a transfer involves shifting funds from one account to another. The transfer authority has long been a source of friction between the legislative and executive branches. Congress has, on many occasions, given the executive branch some flexibility in transferring funds. However, since the executive branch tends to take this authority for granted, Congress has had to exert its authority to subsequently limit the executive branch. In 1950, in the General Appropriations Act of 1951, Congress restricted transfers except where specifically authorized by law. Here's an example of such an authorization. Under this authority, the Secretary of Health and Human Services can transfer up to 1% of any discretionary funds from one appropriation to another with a notification 15 days prior to transfer. This authority is established in law in a general provision of the Labor, HHS, and Education Appropriation Act. In other words, Congress is permitting the repurposing of a small percentage of funds they appropriated under conditions they get to decide. So, Congress provides authorizations, appropriations, and all kinds of legislative history to provide guidance to the executive branch on the purposes for which funds are appropriated. But in many cases, these purposes are broad. For example, what does it mean when appropriating language says, for carrying out Title 26 of the PHS Act with respect to the Ryan White HIV/AIDS program? When faced with broad purposes, the executive branch has to apply what is known as the necessary expense doctrine. This is a test which requires that an expense meet three conditions. It must be logically related to the appropriation. In this case, it must be related to the Ryan White program. It must not be prohibited by law, and it must not be otherwise provided. Following rule number 2 about purpose can be very difficult at times. Some of the thorniest appropriations law issues are concerned with purpose. For example, whether appropriations can be used to purchase food or gifts, or whether they can be used for personal expenses such as clothing or business cards. It's a good idea to ask your Office of General Counsel for help if you have a question concerning purpose. In summary, rule number 2 tells us to be sure we spend federal money only for the purposes established by Congress. Purpose is a key principle of appropriations law. Rule number 3, don't spend more than Congress appropriates, and don't spend money before Congress appropriates it. This is a no-brainer. If the Constitution says that no money shall be drawn from the Treasury, but in consequence of appropriations made by law, it seems obvious that one should not spend more than Congress appropriates. If Congress hasn't appropriated anything yet, it would logically follow that spending in advance would also be forbidden. But remember the friction between the executive and the legislative branch concerning the power of the purse. Congress passed the purpose statute in 1809 to establish limits on what the executive branch could spend appropriated funds for. Doing this tipped the balance in favor of Congress. But that didn't stop some federal agencies from signing contracts for more money than Congress had appropriated for a particular year, and then asked Congress to appropriate more. Especially egregious was the Navy Department's contract in 1870 for the construction and repair of vessels of more than twice the amount appropriated by Congress. This power shift, of course, created some more tension between the branches and caused Congress to pass more legislation in 1870, legislation that has come to be known as the Anti-Deficiency Act, in order to reassert their power of the purse. Here is the original legislation, and here is the codified version in effect today. This act states that government employees may not spend more than the amount that is appropriated, or spend funds before an appropriation is made. The term anti-deficiency refers to the congressional attempt to force agencies to live within amounts provided by the Congress and not create the need for deficiency appropriations. It's important to note that unlike our personal budgets, where we can obligate ourselves to spend money we don't have yet, like for mortgages or car loans, this rule prohibits the federal government from doing that. When the federal government obligates itself to pay for something, it must have a resource to cover it at the time of obligation. In the so-called Adequacy of Appropriations Act, Congress had already established this requirement in 1820, that no contract shall hereafter be made except under an appropriation adequate to its fulfillment. They reiterated this prohibition in 1861. With rule number 3, amount was added to purpose as the second key principle of appropriations law. Breaking rule number 3, spending more than Congress appropriates, or spending before funds are appropriated, violates the Anti-Deficiency Act. Given that Congress wants to control the amount agencies can spend, in addition to restricting spending to amounts appropriated, Congress also prohibits augmenting or adding to an appropriation from sources other than an agency's own appropriation, unless Congress gives permission. For example, the transfer authority mentioned under Rule 2 would be an authorized form of augmentation. Another example of a congressionally sanctioned augmentation is the Economy Act. Under this act, which was originally passed in 1932, federal agencies can receive funds for providing materials, supplies, equipment, work, or services to other federal agencies. The charges for these goods or services must cover the full cost of providing them, or else there could be an augmentation. If you charge too little, the appropriation being billed is augmented. If you charge too much, your appropriation is being augmented. The bottom line is that Congress sets the rules for the amount of money you can spend, whether it's directly, as by an appropriation, or indirectly, like with the Economy Act. If Congress hasn't provided some form of authority for an agency to keep funds collected, these funds have to be sent to Treasury as required by the Miscellaneous Receipts Statute enacted in 1849. The concept of augmentation brings up another provision of the Anti-Deficiency Act, the limitation on voluntary services. This prohibition was first passed by Congress in 1884 and was added as an amendment to the Anti-Deficiency Act in 1905, as shown here, to prevent coercive deficiencies. These were caused by agencies accepting voluntary services and then presenting Congress with the bill. in the hope that Congress would recognize an obligation to pay for these services. The amendment was intended to keep an agency's level of operations within the amounts Congress appropriates for that purpose. If agencies could use voluntary services and then pressure Congress to pay, this would subvert that objective. Congress felt so strongly about these anti-deficiency requirements that they also amended the original 1870 Anti-Deficiency Act in 1905 to add civil and criminal penalties if they were violated. Civil penalties, such as loss of a job, might be imposed, or if the violation was intentional, criminal penalties, such as a fine of $100 or a month in jail, could occur. In 1950, these penalties were increased to $5,000 and up to 2 years in jail. In summary, rule number 3 tells us to be sure we spend federal money within the amounts established by Congress. Amount is a key principle of appropriations law. Rule number 4, spend the money only during the time period provided. We've established that Congress has the power of the purse. This means it not only gets to decide the purpose appropriated funds will be used for and the amount that will be made available, but they also get to decide how long the funds are available to be spent. A time limit on the availability of funds is an important means of congressional control on federal spending. Congress expressed this time concept in the same bill as the original Anti-Deficiency Act in 1870. This statement is codified at 31 U.S.C. 1502. The appropriation is not available for expenditure for a period beyond the period otherwise authorized by law. Generally, fund availability related to time is established in annual appropriations acts. There are 3 different types of time limits or periods of availability that Congress may establish. 1 year, called annual appropriations. More than 1 year, but still limited, called multi-year appropriations. Or no limit at all, called no-year appropriations. 1 year limits are the most typical. Note the language in the first appropriation ever made by our Congress, dated September 29th, 1789, that there be appropriated for the service of the present year, clearly indicating that the funds were limited to 1 year. Most HHS funding is appropriated for only 1 fiscal year. As indicated, this type of account is referred to as an annual account. In the absence of specific language to the contrary, funds appropriated in annual appropriations acts are available for only 1 year for 3 reasons. Section 1301C2 of Title 31 U.S. Code states that an appropriation in an annual appropriations act may be construed as available continuously only if the appropriation expressly provides that it is available after the fiscal year covered by the law which it appears. Appropriation acts begin with statements that indicate the funds are for a single fiscal year. And typically, Congress also includes a general provision in the Appropriation Act that makes this default presumption very clear. No part of any appropriation contained in this act shall remain available for obligation beyond the current fiscal year unless expressly so provided herein. The major point to remember is this. Unless Congress specifically tells you something different, funds appropriated in an annual appropriations act are available for only 1 year. Determining the availability of funds appropriated in authorizing legislation is not quite as cut and dried, however. Questions concerning periods of availability of appropriations in authorizing legislation should be directed to your Office of General Counsel. Here's an example of an appropriation with annual or 1 year availability. Given our default rule, we know these funds are available for only 1 year. Here's an example of a multi-year appropriation. This was made in 2014 and remains available for 5 years through 2018. Some appropriations are available until expended. This means there's no time limit on spending the funds. These types of accounts are referred to as no-year or X accounts, and this is an example of a no-year account. Note the remain available until expended language, which signifies a no-year account. In each of these examples, Congress controls the length of time available to obligate the funds, and Treasury enforces these time limits by establishing amounts appropriated with accounts called Treasury Appropriation Fund Symbols, or TAFs. The Treasury version of the TAFs is made up of 3 elements: a department code, or agency ID number, which identifies the federal agency charged with responsibility for spending and accounting for the funds. HHS is 75. A period of availability, or POA, which is the length of time the funds are available for obligation as stipulated in the appropriating language. A single year or annual period of availability is designated by a 2-digit fiscal year in the TAFs. A multi-year availability is designated by separating the first year of availability from the last by a slash. A no-year period of availability is designated by an X. A 4-digit account symbol which identifies the specific funding provided by Congress. This account symbol is also referred to as Treasury Main Code. The OMB version includes the same 3 elements, but reverses the symbol and period of availability and uses 4-digit fiscal years. There is also a time limit on outlaying these funds. The time limit for outlaying funds that are available for a specific time period, like annual and multi-year funds, is 5 years after the funds expire. For example, an annual appropriation made for 2014 has 1 year to obligate funds, expiring September 30th, 2014. No more obligations can be made after that date. However, payments or outlays of those obligations can occur for 5 additional years until September 30th, 2019, a total of 6 years. A multi-year account made in fiscal year 2014 and lasting until 2018, 5 years, expires September 30th, 2018. No more new obligations can be made after that date. However, payments or outlays can occur until September 30th, 2023, a total of 10 years. A no-year account can obligate funds until they run out, and there is no time limit on outlays. But what if an obligation isn't fully paid within the 6 years? Congress has made provision for canceled obligations to be paid out of appropriations current at the time of payment, up to 1% of the total appropriation. Note that these charges must have been properly chargeable to the closed account, both as to purpose and in amount. The Anti-Deficiency Act continues in force forever. In summary, rule number 4 tells us to be sure we spend federal money within the time period established by Congress. Time is a key principle of appropriations law. So far, we can summarize our rules as follows. Congress has established a set of rules for spending money. It has to be spent for a purpose, in an amount, and within a time period established by Congress. It's only by following these rules that we can have a valid obligation.
Rules 5 through 8 follow in Part 2.